Welcome to a study of the Secure Act sponsored by Chesapeake Legal Counsel. For those of you not familiar with taking a webinar, welcome to the world of high-tech learning. Although you can hear me, I cannot hear you, but that does not mean you cannot ask questions as we proceed. In the upper right-hand corner of your screen, you should see a small question mark. If you click on that box, you should be able to open up and type in a question, and we'll try to take as many of those as we can as we proceed. Or if you prefer, and especially if you are watching a recording of this presentation at a later date, you can always send an email to the office at info@robbertlaw.com. Also, in the box at the upper right hand, as you go down the box, you will see a tab called Downloads. You can download a copy of the slides and follow along if you care to do so. So today we are going to discuss estate planning for your retirement plans. When I use the term retirement plans, I am making reference to all plans such as IRA, 401k, 403b, thrift savings plans for government employees, anything that is deemed to be what the IRS calls a qualified plan. I have many clients who are often confused with what kind of account they have. Most often, monthly statements that you get from your financial advisor will state that the account is a qualified one. Frequently, if you get a consolidated statement, that is one that includes your brokerage account as well as your IRA account, sometimes you have to look a little carefully to see how much is in each of the respective accounts. What we are not talking about today are pension plans that are usually an annuity that ends with your death or the death of you and your spouse, and with no residual left for your children. One of the problems that we have as planners are facing is the fact that the Secure Act became effective on short notice. It was signed into law 1 week and was effective the next. The part of the act that is of interest today, for the most part, only applies to the plan participants who die after January 2020. If you inherited an IRA on January the 1st, that is the beneficiary, your beneficiary is someone other than a spouse, you can continue to take your distributions as originally established. This will be based on your life expectancy. However, upon your death, the new act kicks in so that your subsequent beneficiaries will be subject to the act. As I had mentioned, there are multiple parts to the new law, and I'm not going to discuss all of them. While you are alive, your financial advisor can guide you with the changes that are not pertinent to us today. And those are the things during your lifetime, such as how much you have to take out, how much you can contribute, etc. What we are reviewing today is what happens to your retirement plan upon your death. In very broad terms, the really big change is that the Act now requires most non-spouse beneficiaries to withdraw inherited accounts within 10 years of your death. There are some exceptions, and I will discuss all of these exceptions in some detail. For now, I would just like to point out what the age of majority means. For most states, including Maryland and Delaware, the quick answer to that question is 21, but there is some debate among legal scholars as to whether that age is 26, but that's only for children who are still in school. So for our purposes today, we'll assume that 21 is the age in question, but remember that it can be older in some circumstances. The best way to appreciate what the new law does is to understand what the old law said. First, a term of art. We frequently make reference to RMD. This stands for Required Minimum distribution. Many of you listening became familiar with this concept when you turn age 70 and a half. Fortunately, you're not on camera, so we don't know who you are, but you do. In any event, under the old law, required minimum distribution continued after your death, but then it was based on the life expectancy of your beneficiary. Under the new law, unless the beneficiary falls into one of the exceptions, the beneficiary must take the distribution within 10 years. They do not have to take a little bit each year, but can wait and take it all just in the 10th year. The big benefit of stretching out the distributions is the fact that the retirement plan accumulates tax-free. Some number crunchers who have studied the impact of the new law have shown from an economic perspective, your heirs might be better off not taking any distribution to the 10th year and allowing the investment to grow. That's the power of compounding interest. So the law has three new categories. In regard to non-designated beneficiary, the main thing you need to know is to take care when naming a charitable beneficiary, either as a beneficiary of the plan or as a beneficiary in a trust where the trust is named as the beneficiary of the plan. A full discussion of that situation is too detailed for the time we have today, but keep that in mind if this scenario fits you. When you think of designated beneficiaries, think of your adult children, your nieces, your nephews, or whoever else you might be naming as a beneficiary. At first blush, it seems as if there is not much to do, but name them as a beneficiary and let them pay whatever taxes are due. However, some further thought is necessary depending on several factors. If your children are high income earners, and they will be in a much higher income tax bracket than you are, you might consider a conversion to a Roth IRA. Especially if we're continue in a down market like we are now, the Roth conversion may make a lot of sense. You may want to reconsider if you have a grandchild who is deemed disabled or chronically ill. For example, if your own child dies shortly after you, the assets that were distributable to your child still must be distributed within the 10 years, which could cause an adverse situation for your grandchild. And of course, all of this depends on how much we are talking about. $1 million IRA distributed to one child is different than $1 million IRA distributed to 5 beneficiaries. So your own particular situation must always be looked at. There's no one size fits all for this kind of planning. In any event, in naming children as contingent beneficiaries, look at your beneficiary designation and confirm that it is per stirpes. We use that term quite a bit. What it means is that if a child predeceases you, that child's share goes to the deceased child's children. I point that out because a lot of people take it for granted, but many standard beneficiary designation forms from financial companies are not written that way. So your biggest concern will come if you want to name what the new law refers to as an eligible designated beneficiary. Most clients will opt to name their spouse as the primary beneficiary. This is fine, and the only reason to reconsider is in a second marriage situation where you want your spouse to have the income from the plan, but upon her death or his death, you want the balance to go to your children from a prior marriage. That's a special situation that requires a particular kind of trust to address. Also, note that it is only minor children who can be eligible beneficiaries. The law specifically excludes grandchildren, even if your child has predeceased. Once a child, if you do leave assets or name a minor child as a beneficiary, once that child reaches the age of majority, then the 10-year rule kicks in. So bottom line with that is that you can control the assets being distributed from the IRA until your child reaches at least the age of 31. When I first read about the exception for a beneficiary not less than 10 years younger, I assumed it was designed for those situations where you might name a slightly younger sibling. But on further thought, I think Congress was thinking of all those people who are now living with a partner but not married to that person. In any event, there is that special exception for the slightly younger beneficiary. When you are naming an eligible designated beneficiary, you are inevitably talking about naming a trust rather than the individual person. And we're going to get into greater depth about trust. But let's first look at the exception for disabled and chronically ill. It's hard to distinguish disabled from chronically ill, but you can be one without the other. The disabled category includes anyone on SSI or SSDI. The important takeaway here is that if you do not have a child who still lives at home, who still lives at home for some physical or mental reason, but you never apply for any kind of governmental benefits, you might want to reconsider that decision so that the recognition of your child as a disabled person would be in place at the time of your death. The definition of chronically ill parallels the definition you frequently will see for Medicaid purposes. If you do have a child who is disabled or chronically ill, you will inevitably be creating a special needs trust for the benefit of that child. And this brings us to the question of a discussion of trust. Whenever an eligible designated beneficiary, I got to get used to saying that, whenever an eligible designated beneficiary is named, or you want to name such a person as a beneficiary, in almost all cases, it would be best to name a trust for the benefit of that person rather than naming the person himself or herself. However, to qualify as a beneficiary, the trust has to meet certain criteria established by the IRS. For now, you just need to know that the trust that I create, like many of the people that are on this program or listening, have a revocable living trust. The trust that I create will meet the IRS criteria for being a qualified trust. This includes the trust for your beneficiaries that are included in almost all the revocable trusts that I have created. We frequently refer to the trust for your heirs as subtrusts, since they are created as part of your revocable living trust. These subtrusts can fall into two categories: a conduit trust and an accumulation trust. With the conduit trust, any distribution from the retirement plan must be distributed to the beneficiary. It is the more flexible of the subtrusts and is the one best used when creating the trust for the benefit of a spouse or a minor child. In a blended family, or if you are unduly concerned about remarriage, I would recommend the conduit trust also. During the life of the surviving spouse, the survivor could receive all of the income from the retirement benefits, or the RMD, whatever is greater. And then upon your spouse's death, it could then be distributed to your children. I would also recommend the Conduit trust for minor children. However, a caveat: if you have concerns that any of your children or whoever you're naming as a beneficiary have issues that would indicate that they will not be mature or responsible enough to manage money upon reaching the end life of the Conduit trust, and remember that is age 31, at that age, the entire balance would be distributed to the child, who would have to have full control of the money. If this is a concern, then the accumulation trust must be necessary. The bottom line with the Conduit trust is whatever comes out of the IRA, or whatever the qualified plan is distributed to the trust, but the trust must distribute that money to the beneficiary of the trust. If you want to accumulate, if you do not want to make a distribution to the child or to the beneficiary, then you would use an accumulation trust. With the accumulation trust, the trustee is not required to pass through a distribution from the IRA to the trust. From the IRA is not required to pass through the distribution that comes from the IRA to the trust to the beneficiary. But it does come with some drawbacks. And the big drawback is with regard to income taxes. And we're going to talk a little bit more about income taxes in a second. But let's dwell on the accumulation trust. When is it best used? It's going to be best used if you want to name as a beneficiary a person who has some type of substance abuse, or let's say a gambling problem, or a beneficiary who is a spendthrift. I have a lot of clients who actually say if my child has control of money, they'll just give it all away. The accumulation trust is almost mandatory for a special needs trust. So this would include the trust for the disabled and the chronically ill. But remember that with the disabled and the chronically ill, it's going to be, you have that option of stretching it out over the lifetime of the disabled or chronically ill individual. So you're not going to have to take out a lot of money all at once with those trusts. You also might want to consider an accumulation trust if you have any belief that one of your beneficiaries might need governmental benefits in the future. So you're going to do that as a precaution. It's also I would also recommend that you strongly consider the accumulation trust if one of your children are in a shaky marriage situation, or if they're in a high-risk profession such as a doctor. Or anytime you have a child that is any kind of shaky or precarious financial situation, and your child or beneficiary needs protection from the creditors and predators. Just as a reminder, an inherited IRA is not exempt in bankruptcy, and the accumulation trust is the safest way for a trust beneficiary with creditor issues. So what is the drawback then to the accumulation trust? Income taxes. A trust will always pay income taxes at a higher rate than an individual. Almost all distributions from a retirement plan will be taxed as ordinary income. The big exception to this is the Roth IRA. And that, as you're probably already aware, the Roth IRA is distributed income tax free. And that's because the money that goes into it, you've already paid income taxes on it, but it does have that tax-free accumulation. An individual taxpayer does not pay at the highest rate until he or she has around $518,000 in income, but a trust pays at the highest rate with just $12,000 of income. So that is why if you have a large IRA in an accumulation trust and you get to the end of the 10-year period and it's all distributed at once, then you would have to pay income taxes at the trust rate if you continue to accumulate the distribution in the trust. If you have an accumulation trust and you get the large IRA distribution, but you distribute to the beneficiary the entire amount, then the income tax liability would be shifted to the beneficiary. So as I had mentioned before, if you have ever considered a Roth conversion, this might be a good time to do it since the value of many plans are at a low. And this is especially true if you have a beneficiary that you think you need, that cannot responsibly handle the money, but is not going to be an eligible designated beneficiary, such as someone who is disabled or chronically ill. So it's a tough decision. As a consequence of that tax issue, clients who see the need for the accumulation trust have a hard choice: accumulate and pay the tax or distribute it to the beneficiary. As a practical matter, clients in this situation will want to focus more on how to pay the taxes rather than how to defer them. And they can do this by buying a large life insurance policy or converting the retirement plan to a Roth. So if your situation or your goals or objectives go beyond what we have discussed so far, there are other options available, especially if you want the IRA distributed in a way drastically different from how the way the rest of your assets are being distributed. So in other words, if you have a large IRA and a lot of other assets, and you want the IRA to go to just one or two or particular beneficiaries, you can create a separate trust just to be the beneficiary of that IRA, and the other assets can be distributed according to the provisions of your revocable trust, will, or whatever other documents you have in place. In those situations where you want the IRA to go separately, we create a trust whose sole purpose is just to be the beneficiary of that retirement plan. For those interested in leaving a large legacy to charity, but first want to take care of their children, there's something called a charitable remainder trust that has great possibilities. These are unique circumstances and beyond the scope of the presentation today, but basically in a nutshell, with the charitable remainder trust, you can create a stream of income for your children for up to 20 years. And at the end of that 20-year period, the assets have to go to a charity. Many clients that use the charitable remainder trust will then name what's known as a advisory account, a charitable, what's the word? Can't even think of it right now. But in any event, it's an account where the money goes into a community foundation and your children can be the advisors to that account and give the money away to the charities of their choice. And it works out quite well for a lot of people that do have charitable intent. If you don't have the charitable intent, from an economic point of view, that probably doesn't work out real well. So many of you that are listening today are already clients, and you have a binder full of documents that I created for you. In that binder, we did not put it there, but you should have a copy of all of your most recent beneficiary designations. This would include the beneficiaries not only for your IRA or 401k, but also for your life insurance. If you've created any accounts that are payable on death or transferable on death, all of that information should be in the account. We handle many, many estate administrations, and the biggest problem we have sometimes is trying to figure out what the title is on assets and whether they're automatically payable to someone or not. And if there is a beneficiary, who is that beneficiary? In light of the new law, this would be an excellent time for you to review all of those designations. So, went too far. All too often, completing a beneficiary designation is done haphazardly, name the spouse as primary and the kids as contingent. For many of you, this may work out, but with this new law, more thought should be given to the process. To be honest, the new law has created as many questions as it has answers, and legal scholars are waiting on clarification from the IRS on these issues. But in the meantime, we have to go with what we have. If you are in doubt, send the office an email or call for an appointment. We have the capability of conducting virtual meetings now. We have a software program that allows us to see each other by sight and by sound. And under the new laws in both Maryland and Delaware, we can now witness documents and notarize documents remotely. Takes a little bit of work, but it is possible. So we are still signing documents, including wills, trusts, powers of attorney, and all of the other documents that you have. I also saved a little bit of time at the seminar to answer any questions, but it doesn't look like anybody has asked any questions, no doubt due to my excellent presentation. That's if you could hear the person laughing, that's my wife. I want to thank you for attending the seminar or webinar. This new law, like all things that are new or that make a change, it may take some getting used to, but hopefully you now have a better feel than you did an hour or so ago. Well, not an hour, what did I do? A half hour or so ago. We're going to have some other webinars in the coming weeks and months. Watch the newsletter for details. If you would like to add friends or family to the newsletter list, please send us their email address. A recording of this presentation will also be available on the law firm's YouTube channel, and a link for that can be found on the website. Also, at the conclusion of the seminar, a brief survey will pop up on your screen. Shortly after I sign off, tell us what other topics you might be interested in. And again, if you have any questions that you didn't have a chance to ask during the presentation, send it to us at info@robbertlaw.com, and we'll get to many of those as quickly as we can. So for right now, stay safe, stay socially distant, and we hope to see you soon.